start with succession. We'll just take a couple of important points and then we'll continue our discussions tomorrow. There is really nothing to fear when it comes to succession. Okay? Although understandably a lot of law students have a dread, a fear of succession. That can be traced to one root cause. The reason why most of us took up law is because we thought that law was the course which had the least amount of mathematics. Okay? A lot of law students simply hate arithmetic and mathematics. Of course, in succession, it cannot be helped. There are, as we go along, we will reach certain parts where we cannot avoid but make some computations. But don't worry. In the bar examinations, you will not be asked to make to make complex mathematical computations. You will be asked problems involving distribution. I assure you it will just be very simple cases of computation, if at all. Okay. So, the thing is, as long as we remember basic principles, we will be able to solve whatever problem they may be asking in the bar examinations. After all, the chairperson of this year's bar examination assured the law deans that the thrust will be on basics, basic principles. After all, that is what should really be emphasized insofar as examinees are concerned. What are the things which a new lawyer ought to know? So basics. Okay. What are the basic principles? Oh, well, one very important basic principle in succession, of course, is the primacy of the will of the decedent. Okay? So that's one basic underlying principle of our law on succession. Primacy of the will. To a certain extent, that is somehow mitigated by the provisions on legitime. Diba? Kasi, while generally speaking, the testator has the right to give his property to anyone he wants, to do with his property in any way he pleases, to a certain extent, that right is mitigated by the provisions of the law on legitimes. Kung meron kang compulsory heirs, hindi pwede. You cannot simply dispose of your entire estate in favor of anyone whom you pleases or whom you chooses or whom you choose. The law reserves a certain part of your estate for your compulsory heirs. Okay. That's the reason why, as a general proposition, one basic rule in succession is testacy is preferred over intestacy. Okay? Testacy, testate succession, is preferred over intestate succession. This is somehow related to one of the theories as to the basis of succession. There are several theories. Okay. One theory is that succession is simply an extension of the right of ownership. In other words, if you are the owner of property, you should also have the right, not only during your lifetime, but even after you're dead, to determine who will benefit from your properties. Ikaw may-ari nun eh. So dapat may karapatan ka na magdesisyon kung kaninong mapupunta yung properties mo. Okay, so that's one theory. Succession is simply an extension of the right of ownership. Another theory is that succession is based on the right of the family. Okay? The basis is family co-ownership. As we go through life, as we acquire properties, we have our families with us, okay, who helped us amass wealth. So family co-ownership is the basis of succession, according to another theory. Of course, a third theory would try to combine both earlier theories, extension of the right of ownership as well as family co-ownership. All right. But what is succession? The law gives us a codal definition in Article 774. Succession is a mode of acquisition by virtue of which the property, rights, and transmissible obligations to the extent of the value of the inheritance are transmitted through a person's death to another or others, either by his will or by operation of law. Article 774, if you look at it, already tells us a lot about succession. The law says it is a mode of acquisition. Succession, therefore, by itself, is a separate, distinct mode of acquiring ownership. That being the case, succession is sufficient to transfer and convey and vest ownership in a person. It is itself a mode. Article 774 also says there is a transmission through his death. That tells us another important thing about succession, whether testate or intestate. You only have succession, testate or intestate, if and when there has already been death. That, therefore, is essential for there to be either testate or intestate succession. But what is death? Of course, that's the next logical question. When is a person considered dead? In both medical and philosophical circles, especially abroad, this has been the subject of a lot of debate. When is a person considered dead? Okay. For our purposes, I think we can agree on a basic working concept or idea. A person is considered dead when there has been a total, permanent, irreversible cessation of essential bodily functions. From the point of view of the law, there is no such thing as temporary death. Death is the most permanent thing there can be under the law. If a person, for example, is rushed to the hospital at 7 o'clock in the morning, he has obviously suffered a massive heart attack, rushed to the emergency room of a hospital, no less than 2 different doctors said he is dead. DOA, dead on arrival. And so, after that, the doctor signed the death certificate. He's taken home by his relatives. He is appropriately dressed in the proper attire for the wake, and he's laid out. At 11 o'clock the same morning, he suddenly sits up, asks for a glass of water and some food, which is not an outright impossibility. Okay? I always tell my students, I even read an entire book about these types of experiences. Okay? Remember in the in that play by Shakespeare, yung sa Romeo and Juliet, di ba? One of them was supposed to have taken a potion which would produce effects similar to death. Okay. Kasi ang title ng book is The Romeo Factor. Okay. So it has happened in a lot of cases, many times in the past. This has been documented. The question is, was there succession from 7 o'clock in the morning up to 11 o'clock that same morning when he appeared to be dead? The answer is no. No such thing as temporary death. Okay? You're either dead or not, but no temporary death. Okay. In succession, there are the so-called subjective elements and the objective element. What are the subjective elements? The person who died. Yan ang bida dyan. And those who succeed him. His heirs, legatees, devices. The objective element is the inheritance. And this connection, you remember the most important provision in succession. I refer to Article 777. That's a very useful article. As we go along, you will realize that many other provisions in succession are actually premised on the principle, the rule contained in Article 777. After all, it's one of the shortest provisions in the Civil Code. The rights to the succession are transmitted from the moment of death of the decedent. If a person dies at 7 o'clock in the evening, from that very moment, okay, successional rights are already transmitted. Kahit na sabihin nating medyo mainit-init pa yung kamamatay na tao. Okay? Successional rights are transmitted from the very moment of death. Okay. It is from that moment when there is a transmission of rights. Up to now, one of the best illustrations of this principle is still that old case of Lorenzo versus Posadas. A person died. In that will, in the will which he left, sabi niya, I give all of my properties to my nephew. But he said he will get these properties only after 10 years from the time of my death. In the meantime, the properties would be administered by his executor. The question which arose is this. In determining the amount of taxes due, which should be used as basis? The value of these properties at the time of death or the value of these properties at the end of the 10-year period when they are supposed to be delivered to the heir? Applying what is now Article 777, Supreme Court said, of course, it should be the value at the time of death. Because it is at that moment, at the moment of death, when there is a transmission of successional rights. Of more recent vintage, you have the case of Locsin versus Court of Appeals. In that case, which is quite similar to the case involving the estate of the late Doña Chito Madrigal. Okay? Sa case ni Doña Chito, ang mga survivors are only nephews and nieces.